I call the honourable member David Clendon.
Thank you, Mr Speaker. Tēnā koe. Mr Speaker, this bill is another in a long string of corrections bills that we've seen from this government. The last term saw a number of corrections bills moved through the legislative process, passed into law, that were extremely unhelpful in terms of reducing crime, reducing recidivism, making our communities safer, reducing the economic and social costs of crime. We saw, for example, the 3 strikes legislation, the introduction of private prison management. We saw from our departed friend Mr Garrett, we saw the gratuitous removal of prisoners' right to vote. We saw the double bunking, the conversion of containers, shipping containers, into accommodation for 2 prisoners at a time. All of these measures revealed a government apparently in thrall to the very vocal but equally misguided minority in this country who believe that somehow we'll achieve our objectives through longer and tougher sentences. So all the evidence and the research tells us that most New Zealanders understand very well that that is not the route to a safer community. So New Zealanders are much less interested in punishment for its own sake. New Zealanders want to see policies and practices that will reduce the social and financial cost of crime, that will make people feel safer in their communities. We know that all but a handful of the most serious offenders will ultimately be released back into society. We want to see those people fit to re-enter society with a positive contribution to make and an attitude that will enable them to break out of that cycle of offending and re-offending. Is there any hope, perhaps, that a new term of Parliament and indeed a new minister might see a somewhat more enlightened and progressive approach to corrections would seem to be dashed by this bill, which again does reflect a particularly unpleasant, punitive approach to the whole question of corrections. So the stated aim of this bill, and I quote, is to remove barriers to managing prisons in a manner that is safe, secure, humane, effective and efficient. And I would argue that there are provisions in this bill that almost guarantee that we will fail in achieving any of those objectives. We won't achieve one single one of those, given what is concealed in this bill. So to the contrary, this bill takes away from inmates some very basic human rights, protections from abuse. It provides prison officers perversely with an incentive to step outside of good professional conduct. It makes them more vulnerable to accusations of misconduct. It provides incentives for prison managers, in particular the private sector managers, to reduce prisoners' eligibility and therefore access to rehabilitation and reintegration programs, again at odds with our stated objectives. So it's difficult to see any redeeming feature in this bill. We see it as requiring a complete rewrite. We don't think simply amendment would be sufficient, and for those reasons we'll not be supporting its progress to the Select Committee. So the bill makes significant changes to the provision of health services in prisons in a way that seems more driven by issues of cost saving and convenience rather than a genuine concern for the well-being and the health of prisoners. It's well known that prison inmates typically come with very high health needs due to lifestyle, environmental factors, a host of reasons. Prisoners are susceptible to illness. Their health status generally is below that of the population, of the general population. This was very well encompassed in the report from the Ombudsman that we've heard referred to already, that came out just a week or so ago. And to be fair, there is an acknowledgement in that report that prisoners currently have reasonable access to health services. It also points, however, to some significant shortcomings in healthcare and warns us, and I quote, that in future the service may not be able to effectively meet the healthcare needs of the diverse prison population. That is a red light. That is a warning bell from the Ombudsman, a disinterested, objective observer telling us we need to address healthcare issues in prisons. And unfortunately, this bill does that, but it does it in a way that, to our mind, actually takes us some steps backward rather than moving forward. The bill seeks to downgrade the service, the status of the service, if you like, by taking overall responsibility for health services away from medical officers, in other words, medical practitioners, and instead delegating to health centre managers who may be nurses, directly employed by corrections, or in some cases contractors in the case of private prisons. This runs absolutely at odds against the recommendation of the Ombudsman, who says, and I quote again, health services should be funded and delivered by an agency whose primary focus is health and therapeutic support, not custodial. And that reflects, it echoes the recommendation of a report from 2010 of the National Health Committee, the report entitled Health and Justice, which again advocated very strongly for putting health services into the hands of an external agency, not leaving it in the care of corrections. We would not put corrections in charge of health, nor would we put health in charge of containing custodial practices. Why would you do that? So the current legislation states quite clearly there must be at least one medical officer that is a qualified medical practitioner in every prison. This new bill in Clause 8 says that, quote, for every prison there must be a sufficient number of medical officers to meet prisoners' needs for medical care and medical treatment. So the obvious inference of that a number less than one may be deemed to be sufficient. Are we suggesting a part-time prison medical officer, someone with responsibility for a number of prisons? Are we suggesting a person less well qualified than a medical practitioner to look after the significant health needs of often quite large numbers of inmates? That is a very subtle but a very dangerous provision, we believe. A minimum of one is being reduced to this very vague, ill-defined, amorphous notion of sufficiency. Again, this would point to a cost-cutting approach. We know, and experience has told us repeatedly, that short-term cost cuts in healthcare, be it in prisons or anywhere else, inevitably leads to longer-term social and indeed economic costs further down the track. So again, in the general area of prisoner health, currently prisoners have a minimum entitlement to 1 hour of exercise every day. Ideally taken outside if weather permits. This bill takes away that minimum provision, that minimum entitlement to 1 hour of exercise in the event that a prisoner is outside of the prison, particularly through the normal working day, if you like, 8 to 5. The prisoner can be denied access to exercise if, for example, he or she is being transported that day, or if they are in court for a hearing, for whatever it might be. There seems to be no limit on the number of times this denial of this minimal entitlement can be applied. Conceivably, a prisoner who is in court for a number of days could go several days without physical exercise. Those of us who in a different way are imprisoned in this house on occasion know very well the value of exercise to people. Lack of exercise for a prisoner could lead not only to less than ideal health, but certainly the attitude, their mental well-being can be negatively impacted by that denial of that basic minimum entitlement to 1 hour's exercise. So we note also with some concern that a health centre manager may now prescribe a special diet for a prisoner. Currently, it is only a medical officer who may prescribe a special diet. And again, these are all examples where the prisoner's well-being has been just slightly nibbled away, and the net result, the cumulative result, could be quite serious in terms of prisoner health and well-being and the general safety, not only of the inmates, but also of the staff and people in those prisons. So the issue of the right of a prisoner to appeal their security classification. Currently, that will be determined by the Chief Executive, a very high-ranking public servant, directly answerable to the Minister. It will now be possible for a person employed by a contractor to be in the role of making that call as to the security classification of a prisoner. Mr. Charles Cheval, has outlined the constitutional concern around that. A much more practical concern, equally, would be that the private providers in particular will be motivated towards assigning a higher rather than a lower classification for reasons of cost saving. They are more secure if the prisoner has a higher classification. The likelihood of them suffering the fate of Serco recently, a $150,000 fine for allowing a prisoner to escape, would be reduced. The eligibility of prisoners for programs such as Te Whare Oranga Ake would be removed if they have not got the minimum classification. This is an absolute motivation and incentive not to take a very small risk of giving those prisoners that classification, which allows them access to these programs that gives them a much better likelihood of success in the community. Thank you, Mr. Speaker.
I call the Honourable Member Jonathan Young.